Miriam. Thank you very much. Um, Hello to everyone. I'm very happy to be, leading this seminar today, and I thank the organizers, and Miriam in particular, for inviting me. It's always a pleasure to meet an audience who is expert and with which a dialogue, a conversation can happen. I've been asked to talk about the human rights of migrant workers in the universal regional systems. I will focus on the universal system with some references to the African systems, a few references to the African system. And I will also talk about the Global Compact on Migration, which is an evolution in the human rights doctrine and how states consider migration. And we'll see that there's a constant evolution on those issues. So I'm sharing my screen with you now. Yeah. Do you all see this? All right. Yes.
We do, yes.
Yes. Good. So. We'll start with what the law is at international level, and then we'll move to what it should become. That's the flow of the presentation. If I can change slides. Now, my slides are not obeying my command. Here we have it. So, 4 points during this presentation, and I've been asked to speak 40 to 45 minutes so that we have 45 minutes for discussion, a bit less now because of the technical difficulties. The first point is migrants have rights, contrary to some popular beliefs. Second, that migrants' precarity is constructed. Third, mobility can and should be governed differently. And finally, the way forward. How can we plan human mobility while respecting the human rights of migrants? And the focus of this presentation is about migrants who live in precarity. I'm less concerned, not concerned, but usually I'm not concerned with expats or tourists or mobile executives. I'm interested in people who have human rights issues in the country where they work, who have vulnerabilities, who have little social capital, and who live in a precarious situation. And we will discuss this precarity, the precarity in question. Migrants have rights. There is an international legal human rights regime. This regime is a complex system of standards, institutions, and practices. And we see it at universal level, at regional level, at national level. At universal level, we have the UN system, essentially. At regional level, the Council of Europe, the EU, but also the OSCE, for example, the African system, the Inter-American system. So you have different mechanisms that overlap each other. And all this has developed, all these international systems have progressively developed a human rights doctrine in international law, inspiring, each being inspired by what is happening in the other systems, and they are borrowing from one system to another, etc. So there is this evolution of the human rights doctrine in international law. And at national level, which contributes greatly to the developments at international level, you have the guarantee of human rights in constitutional standards in many countries, national human rights institutions, and the role of the judiciary, and I'll insist on the role of the judiciary a bit later on. And at national level, very often there's also a case law and a doctrine about the human rights of the people on the territory of the country, which gets inspired by the international system, be it universal or regional, if only because the country will be the subject of case law at regional level or of decisions by, for example, human rights committees at the UN or reports by special procedures at the UN. And so there is some reaction to that. So there is an interpenetration of all these systems, and they feed each other intellectually. In the international human rights regime, rights belong to all human beings. And that means not all human beings, comma, except migrants or minorities or women or etc. It means all human beings. And you can see, for example, in the Universal Declaration of Human Rights, the text that I have put on the screen, everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as, and we see national or social origin, which includes the distinction of nationality. So the rights and freedoms guaranteed by the 1948 Universal Declaration are available to all, including all migrants. Now, this needs to be interpreted, and that's where we're going. In the Vienna Declaration in 1993, it was said that all human rights are universal, indivisible, interdependent, interrelated. So we have to interpret all the rights of all human beings in relation to one another. There's no freedom of association if you don't have a right to unionize. This is the kind of correlation between rights and between human rights system, in this case, the ILO systems that you've already, I think, seen, and the human rights system that needs to be made. They are interdependent and interrelated. The Universal Human Rights Architecture, I'll give you the main texts, and many of you know them. The Human Rights Charter is made of the Universal Declaration and the two covenants on civil and political rights and economic, social, and cultural rights. You have related regimes, the regimes on genocide, the conventions on international humanitarian law, the Geneva Conventions of 1949, but also the Geneva Convention of 51 on the status of refugees and their protocols. And then you have specific regimes which have been crafted in order to expand from the covenants and address specific issues about a number of people or a number of issues. So one is racial discrimination, so elimination of racism. One is elimination of discrimination against women, CEDAW, very well known, 1979. The Convention against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment, 1984. Convention on the Rights of the Child, one of the most ratified human rights conventions, in 1989. The International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families in 1990, and I will come back to that specific convention. The Convention on the Rights of Persons with Disabilities in 2006, and we have to remember that, and finally enforced disappearances more recently. And we have to remember that migrants can benefit of all of these regimes. A migrant might be a woman who is racialized and who has suffered degrading treatment and who is underage. So it's a child, according to the Convention on the Rights of the Child, and may have a disability. So you might have a migrant worker who is protected by all these, and they're also protected by the covenants. So you see, you have this, all these texts are absolutely crucial to the protection of the rights of migrants. In the human rights regime, the international human rights regime, only two rights belong to the citizen, only. The right to vote and be elected, take part in the conduct of public affairs, and the right to enter in one's country, one country of citizenship. So that these are reserved to the citizen, and you see it in Article 25 and Article 12 of the International Covenant on Civil and Political Rights. And you can see something a bit equivalent in the African Charter, which is, I find it interesting. Citizens have, as in the Covenant, the right to participate in the government of their country through freely chosen representatives. So that means right to vote. And the Charter adds something which is not in the international system, which is reserved to citizens, is equal access to public service, i.e. to become a civil servant. Now, this is specific to the African Charter. It's not in the international human rights regime, universal human rights regime. It's a limitation on the rights of foreigners to access public service. It does not prevent it, but it does not give equal access to foreigners. And that's an interesting twist. And we see so that there are regional specificities like that. All other rights belong to all human beings. And you see here the ICCPR and the International Covenant on Economic, Social, and Cultural Rights. You see that undertakes to respect and ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as, and we see again, national or social origin. And you see here something important, all individuals within its territory and subject to its jurisdiction. So that means that they have to be on the territory, and they also have to be subject to its jurisdiction. And some people are outside the territory and still subject to the jurisdiction. For example, if migrants are picked up on the high seas by a ship with a flag, they are considered to be within the jurisdiction of the state of the flag of the ship. And they are under the jurisdiction of that state, even though they're not on its territory. There's an analogy with territory saying that the boat is actually fictionally considered the territory of the state, but it's a fiction. They're not on the territory. They are but they are within the jurisdiction of the state. And there is a case law in the European Court of Human Rights on those issues. And you see that we have the same type of provision in the Covenant on Economic, Social, and Cultural Rights. And so these human rights are for all. And that means, for example, and we'll go through a few of those, the right to equality and the freedom from discrimination. It sounds, for many people, to say that foreigners have the right to equality sounds bizarre, but that's what the human rights doctrine says. Freedom of expression, freedom of association, etc., right to an effective remedy, right not to be sent back to torture, children's right, decent work conditions, right to public services. And this is true even in a security context. And we know that migration and migrants have been associated to insecurity, and that migration policy have been securitized over the past decades, especially since 9/11, but it started earlier than that. And so even in a security context, in the international human rights doctrine, people have rights, and that's everyone, citizens or foreigners. And so we'll go through that quickly. For example, the foreigner has the right to equality. So this is, as we've seen in the International Covenant, without distinction of any kind, such as national or social origin. Now, the interpretation of this is not always easy. Distinctions are possible. For example, children cannot vote in most countries. Before 18, you cannot vote. Now, there might be other rules in different countries, depending. Some countries you can vote at 16. Some countries you can be in the army at 16, but or other countries you cannot be in the army before 18. So you have distinctions that exist and that can be justified. The vote at 18 is usually justified because it is considered, whether it's right or wrong may be debated, that children under 18 do not have the political understanding and sophistication necessary to make enlightened decision at a political level. And we have come to accept that. That's a distinction which can be justified. If a distinction is unjustifiable, then it's discrimination. And every time we have to decide whether a distinction is or is not justified. And very often this goes to court. For example, in many armies, women were not allowed to be soldiers or to be in units that were on the front line or to be in submarines. And women have fought to find their own place in the armies of their country. And in many countries, courts have come to recognize that some of those distinctions are unjustified, and women have found a place in the army, in the armies of their country that fits what they want to do. And so there is here an evolution of the doctrine of human rights. As generations pass, we have a different understanding of why we make distinctions between people. Very often, if you look at the policies, the practices, the laws regulating migration, you will see that many countries consider immigration as a privilege, that immigration is in the realm of territorial sovereignty, and that states should be able to do whatever they want with migrants because they don't belong to the population, and if we're not happy with them, we can send them back. That's a common discourse about migration, but it's a discourse that does not correspond to the reality of international human rights law. In international human rights law, you cannot do whatever you want with migrants. You have to respect their rights, and they do have rights. So that's one of the important consideration that has to be kept in mind when we deal with migrants. Migrants have, in essence, the same rights as citizens, except a few, and there are distinctions that are acceptable. For example, a migrant can be sent back to their country of origin if they commit a crime, if they are not there, legally, and they have no connection to the country whatsoever. They can be sent back. You cannot do that with citizens. You cannot expel a citizen. So there are distinctions that are possible, but in essence, migrants have the same rights as the same fundamental rights as citizens, and we have to remember that. It's not self-evident for many people. Sorry, I have to here. The foreigner has a right to a remedy. So that's interesting in the covenant and in the African Charter. It says, so in the covenant, any person whose rights or freedoms are herein recognized are violated shall have an effective remedy. That's the basic rule. You have the right to find someone who can judge what's happening to you and decide to restore your right or your freedom. And you have that in the African Charter. Every individual shall have the right to have his cause heard, the right to an appeal to a competent national organ against acts violating his fundamental rights. You see, so it's expressed differently, but it's the same idea. People, every individual, not citizens, every individual have the right. And we'll come to the distinction between criminal law and administrative law on this a little later. And the remedy must be effective. And I want to give you an example from Canada of ineffectiveness of remedies. In the Immigration Act of Canada, 40 years ago, most decisions could be appealed. And in recent years, in the past 20 years, this has been entirely replaced by judicial review. For those of you who are not lawyers, an appeal means that a superior body, let's say a court of appeal, will make another decision and replace the previous decision on everything. A judicial review in a judicial review mechanism, which is for judicial review of administrative decisions, the reviewing body will only decide on issues of law, not the questions of fact. They leave the appreciation of the facts to the first decision maker. But they will review the questions of law and they will decide whether that decision was reasonable, considering the facts that have been accepted. And unfortunately, on many immigration decisions, they're based on facts, and therefore they're not really reviewable. If you say, for example, to an asylum seeker, I don't trust you, I don't believe your story, this is an appreciation of fact. And in most cases, it will not be reviewable. And so in Canada, we have, in effect, taken away an effective remedy. Now, later on in the history of Canadian immigration law, we've added a refugee appeal division, which actually can make a different decision, but it took a long time to get there. For a very long time, many decisions were not reviewable. Moreover, and that's also an issue, many states, including my own, have imported into immigration law some norms, institutions, and practices which is found in criminal law. For example, detention mechanisms. The detention centers that are built for migrants today resemble maximum security prisons. Anti-terrorism mechanisms, etc. This has been imported into administrative law of immigration. And yet, administrative law does not include the guarantees, the rules of evidence, and the guarantees of procedure that criminal law has developed over several centuries, because it used to be the most dangerous law of the land. It was the law that could get you killed, tortured, or detained. And so criminal law has developed rules of evidence and rules of procedure that protect the innocent. In administrative law, which up till recently, was only the law of, zoning laws and building permits and fishing permits, and this was administrative law, those rules have not been developed because it was not a dangerous law. Unfortunately, in a country like Canada, where we don't have the death penalty, we certainly don't have a policy about torture, and we have rules about detention, and we cannot send back to countries who have the death penalty. The only judge who can send people to extrajudicial execution, torture, or arbitrary detention is the immigration judge today. And that immigration judge does not preside over a process in which the guarantees of procedure and the rules of evidence will protect the innocent like they are protected in criminal law. So we also have here something which is fundamentally problematic and has not yet found a solution in most countries. So, for example, in Europe, deportation to torture is absolutely prohibited. Saadi versus Italy decided that in 2008. There's no exception whatsoever. But in Canada, the Supreme Court of Canada in 2002 said that in exceptional cases it could happen. And we have a case at the Human Rights Committee, if I'm not mistaken. No, it's the Committee Against Torture, sorry. Dada versus Canada, where Mr. Dada was returned to Iran, and the Committee Against Torture of the UN said that he risked torture if he was being returned to Iran, and he was returned to Iran by Canada. Canada did not follow the decision of the Human Rights Committee. So Canada is probably deporting to torture, which is eminently problematic. All children are protected against discrimination. We have that again in the Convention on the Rights of the Child. So you see, I've quoted here a few sections. ensure the rights set forth in the present convention to each child within their jurisdiction, without discrimination of any kind, and irrespective of the child's national origin or other status. In Article 2.2, the child is protected against all forms of discrimination or punishment on the basis of the status of the child's parents. So if in a country a child was born in the country of immigration and has the citizenship of the country of immigration, but the parents are undocumented, for example, well, the question is, how do you treat the child? Do you treat the child as a citizen, or you treat the child as the son or daughter of undocumented migrants who should go back to their country? And so here, there should be no discrimination whatsoever or punishment. And in all actions concerning children, the principle of the best interest of the child shall be a primary consideration. So you see, this is absolute protection of all migrant children. Each child within their jurisdiction means all migrant children are included. And I've given a few bad examples about what Canada does. Let me give you a good example about what Canada does. In Quebec, in my province, the children of undocumented parents very recently have had access to public education and to healthcare. And this dates back 4 years for the right to education, and last fall for the right to health. They have access to public healthcare. Not pregnant mothers and not their parents yet, but at least children are protected and they have access, which is a good thing. Right to public services. We'll talk about that a bit later as well when we talk about the Global Compact. But here, in the Covenant on Economic, Social and Cultural Rights, state parties to the present covenant recognize the right of everyone. It's clear, it doesn't exclude anyone, to social security, including social insurance. And in the African Convention, every individual shall have the right of access to public property and services in strict equality of all persons before the law. These are very clear words. That doesn't exclude migrants. Now, how do you interpret that might be an issue. You know, how you have contributing social insurance and you have non-contributing social insurance. And then you have to discuss each case. But the principle is access of migrants to public services generally. Even in a security context, and I'll tell you that's another Canadian story, but many countries have faced calls by politicians or political parties for securitizing migration and making decision about migrants based on security concerns. Now, the response, and you've seen the distinction between administrative law and criminal law, the response in many countries for governments has been to expedite deportation for migrants or foreigners who are suspected of being dangerous. But one decision by the Supreme Court a few years ago, 15 years ago, said many of the principles of fundamental justice were developed in criminal cases, but their application is not restricted to criminal cases. They apply whenever a protected interest is engaged. Put another way, the principles of fundamental justice apply in criminal proceedings, not because they are criminal proceedings, but because the liberty is always engaged in criminal proceedings. And liberty is also engaged in administrative proceedings in administrative law of immigration. There's another quote from the same case, which is, I would say, the up and coming interpretation in international human rights law. The overarching principle of fundamental justice that applies here is this: before the state can detain people for significant periods of time, it must accord them a fair judicial process. And when they say people, they mean everyone. They don't mean only citizens. And that brings forward the idea that since, and we'll talk about the fact that politicians have difficulty defending migrants in situations where migrants are accused of being dangerous for various reasons, the judiciary is the essential line of defense of migrants. The courts have, in many cases, told the governments, no, you can't do this to migrants, because they are protected by the Constitution, they're protected by the law, by international law. Even the American Supreme Court told the White House that they could not, that people in Guantanamo Bay had rights. That was not the interpretation of the American government, because it was in Cuba, it was outside the US, etc. But the Supreme Court said, no, these people have rights. They may not have all the rights, they may not, but they have rights, and you can't deny them that. And we have to remember that the foundations of democracy is not simply the election. The election is only one element of democracy. Democracy rests on representation. It's absolutely necessary. We need political representation. We need a majority, but majorities can be wrong, and therefore we also need human rights guarantees, and we need the rule of law. And the rule of law here is interpreted as access to justice, the capacity of one individual or one group to go to court to tell the majority, yes, you are wrong. You cannot do this to me or to us, because our rights should be protected and guaranteed. And so that's essential for migrants, as it's been essential for minorities, for Aboriginal people, for industrial workers, for women, etc. They need the possibility of going to court, and that courts have the legitimacy to tell the elected majority of the people, representatives of the people, you're wrong. You are representing the majority of the people. You've been elected to do that, but you're still wrong, because you cannot trample the rights of minorities. So that is something we need to remember, because it applies to migrants as it applies to other minorities in our countries. Now, there is one convention I mentioned at the beginning, the 1990 International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. It is a poor cousin convention, unfortunately. It was negotiated in the 80s, and the human rights doctrine was not as well developed at that time, and the protection of migrants and the reflection on how migrants should be protected was not as developed as it is today. And one fundamental feature of this convention is that it will protect differently migrants with regular status and undocumented migrants without status. So there are two sections. Section 3, or part 3, maybe part 3, enumerates a number of rights for all migrants. When they say all migrants, that includes undocumented migrants. The right to life, protection against torture, slavery, freedom of religion, freedom of opinion, freedom of expression, right to privacy, property, liberty, freedom from collective expulsion, urgent medical care only, mandatory education only, etc. But Part 4 adds some rights for migrants who have a legal status. For example, freedom of association and freedom to form trade unions is reserved by this convention to migrants with status. And we know that around the world, some trade unions have started to enroll as members undocumented migrants. Not that many, often in agricultural sector, but this has started. And this is it will often be through trade unions that the protection of undocumented migrants will happen, because collectively they will they will gather sufficient strength to be able to negotiate with employers. There's no access of undocumented migrants to other forms of education, vocational training, housing, health and social services, cooperatives, work in businesses, etc. And protection of the family. There's no right to reunification for undocumented migrants. And so we'll see how the Global Compact on Migration, adopted almost 30 years later, has a different take on these issues. And in that convention, there's also a distinction made between criminal detention and administrative detention. Criminal detention offers many more guarantees. So if a migrant is accused of a crime, they will be much better protected than if they're simply, detained and expelled under administrative law, which is considered bizarre today. It's not a guarantee that it's not a distinction that today would be accepted in how the human rights doctrine has developed since the 80s. Also, there's a difference between migrants and nationals regarding social security, access to social security. Now, this convention, unfortunately, has only been ratified by 57 states. The last one was Chad in February 2022. There's not one single Global North country, and when I asked a representative of the Canadian government a few years ago, I was told that this is a group of 77 convention. It's not for us at all. We're not interested in ratifying it at all. And somehow it hasn't gathered traction with major countries of immigration, although Chile, Argentina, for example, have ratified the convention, but big countries like the US or Canada or Australia have not, and certainly European countries have not, and there has been pressure not to ratify, even though a number of European countries were ready to ratify it. We will see the difference between this convention and the Global Compact a little later on. Oops, sorry, I want to move that out of the way. Yeah, here. Now I can move, yeah. So my next section is about how the precarity of migrants is a social construct. Sorry, I still have to do this. Yeah, good. So we have to understand that migrants come to a country of destination in their vast majority because there's a job, because there's a labor market for them. And a labor market which can be a regular labor market, with a contract, etc., or a temporary labor market, or an underground labor market. Migrants, in general, do not go where there are no jobs. Why? Because migrants take the difficult decision to migrate, and often migrate by themselves, all alone, to create a future for themselves and their family. That's the objective. And you don't go to a country without jobs if you want to do that. So migrants are called by labor markets that offer jobs to them. And in countries of destination, many industries, many labor markets rest on cheap labor. It's cheap labor that makes them competitive. Very often they have low profit margins. They're not delocalizable. For example, agriculture, a Canadian strawberry cannot be grown in Costa Rica. A Canadian strawberry has to be grown in Canada. And if you want to have a strawberry industry in Canada, well, you can't delocalize it. And so the most important industries where you have these huge labor markets for migrant workers are agriculture, care, construction, extraction, fisheries, hospitality, domestic services generally, if that could be included into care. And this is very well known, and there is almost no oversight. So migrants who find themselves in these industries are often treated very badly in terms of wages, working conditions, housing, care, etc., etc. And what is important here is that the precarity is a political, social, and legal construction that comes from the combination of migration policies that put them at risk of being sent back home empty-handed at any time, and labor policies where the rights are not respected but no one cares. And they don't dare speak up for fear of being sent back. And that is one big problem. The fear of return means that they're silenced by the type of treatment they get. They don't, very often, they won't protest, they won't contest, they won't unionize, they don't go to court. Often, some do, but it's the tiny minority. The vast majority will just accept that, and if they can't accept it, they will try to move on, often undocumented, and find another job with another employer and try their luck. And they have little options. They have to accept the working conditions if they want to send money to their families. So that's the position in which they're in, which is a very difficult position. And we all know this. This has been documented by sociologists, labor specialists, lawyers for decades. It's not like governments don't know that. The problem, that's what I've mentioned, is that this is policy induced. It's a strategy nowadays. It's a strategy to reduce labor costs. All the policies against undocumented migration, repressing undocumented migrants, despite the fact that we know we have labor needs in those fields, and we don't acknowledge that. If you block migration despite a need for low-wage migrants, well, that means that if the government doesn't provide mobility options, other people will provide mobility options. And therefore, this prohibition of undocumented migration will create, entrench, and subsidize underground markets that will respond to the need of employers. Smuggling rings, unscrupulous recruiters, exploitative employers, greedy lodgers, loan sharks. All these will profit from the precarity in which migrants are consciously put in order to reduce labor costs, because we know that they will accept labor conditions that citizens would never accept. And they have no choice. It's that or they're returned home. And they don't want to return home because they have to protect and sustain their family. And that's true for temporary labor migration programs, which are legal migration, official, regular migration, but where we create a precarious status. So, for example, the single employer temporary status, where you can't change employer, means that if the employer fires you, you lose your residence permit and your work permit, and you have to go home, which is extremely problematic. That's why you will accept abuse and try to live through abuse, because you don't want to lose your job. You don't want to go back home empty-handed. We know that in many countries, for example, in Quebec, in my province, in Canada, domestic workers are not subject to health and safety regulations. So they live in houses of their employers, but that house, which is also their workplace, it's their house and their workplace, is not subject to health and safety regulations. So they can be placed in a very unhealthy situation and no one will know. Inspections are absent in most countries, and that's north and south. Labor inspections do not care for undocumented workers. They do not protect the rights of undocumented workers. Very often, labor inspectors will go hand in hand with immigration officers and try to catch undocumented workers, which is not their role. Their role is to have labor law rules applied to all workers. But in most countries, including mine, that's not what's happening. Unionization is discouraged or prohibited. In Quebec and Ontario, agricultural workers are prohibited from unionizing. Now, this is only possible because the vast majority of agricultural workers are foreigners. If they were citizens, unionization would not be prohibited. And protesting is punished in many cases. Now, precarity is encouraged by irresponsible political discourses. We have a problem with the best system we've ever invented to govern ourselves, which is electoral democracy, where everyone quotation marks, have a say in how the government is doing and can punish or reward politicians. And politicians work with electoral incentive. They will try to do what will make them reelected. And that's how the people can, push politicians to do the right thing. And we cannot blame politicians to not do whatever does not give them any electoral incentive. And the fact that migrants do not vote means that most politicians have no electoral incentive to help migrants and to protect their rights. On the contrary, if there is a mobilizable electorate on migration issues, it will often be an anti-immigration electorate who will place ideological issues above other issues. And that's problematic. We have difficulty. If migrants, if people need to have their rights protected in an electoral democracy, they have to fight for them and they have to convince politicians to do the right thing. And this is not happening. So what we have in migration policies today is that they're made by non-migrants, the politicians, for non-migrants, their electorate. And it's like when policies about women were made by committees of men. They have no idea what they're talking about, and they serve their electorate. Committees of men, politicians who are all men and discussing women's issues, were serving their electorate, who were all men before women got the right to vote. And that's how policies about women were done. And that's what we have today with migrants. Often there are myths, stereotypes, fantasies that are at the basis of many of those migration policies, that migrants bring unemployment, crime, illnesses, that asylum seekers could be terrorists. And for some politicians, the idea of a permanent immigration crisis is actually a good thing. They thrive on the idea that they can ask the people to throw away these migrants, etc. And this is not helped by the language we use about migrants. We often talk about flows and waves and tides and floods of migrants, that they're trickling, streaming, swelling, pouring through the border. This conveys the image of a mass of people who are not individuals, who are just a mass, like toxic sludge or something like that. And we use very often a criminal law language nowadays. Yet, migration is in the DNA of mankind. We're all descendants of migrants. And actually, if we go back to the first sapiens, we're all descendants of migrants from Africa. The oldest examples of our species were in the Rift Valley and in Morocco. There was a fossil found 3 years ago in Morocco, which is about 300,000 years ago. Migration is a normal coping mechanism, and it will not change. People will move, whether we like it or not. People will move. So the more we repress that mobility, the more we disempower migrants, the more we empower their criminal exploiters. And we are subsidizing criminal organizations who help migrants instead of states owning the market of mobility by giving migrants the right papers. The costs are indecent, be it financial costs, building the wall, as Donald Trump has tried during his presidency, or the financial costs, or the human costs, the number of people who die trying to move, trying to help their family. But it's for migrants, often the human costs and the financial costs of borrowing money and not being able to repay, but also for host societies. When we will realize how much money is spent in our names, we taxpayers, to prevent people who could help us develop our country from coming, we will realize that this is money not well spent. So there has been a change, a slow change of mentality, of perspective. Mobility can be governed differently. And that we can see already in the Sustainable Development Agenda of 2015. There was a concerted effort to bring migration and human rights into the SDGs. And you see how by adding the word all or for all inside the goals of the Sustainable Development Agenda. And a few targets are directed at migrants. And one of the most important ones are the first two here. The one about protecting labor rights and promote safe and secure working environment for all workers, including migrant workers, in particular women migrants and those in precarious employment. So that's, the ILO is responsible for developing this target and for helping states develop this target. And 10.7, states committed to facilitating orderly, safe, regular, and responsible migration and mobility of people. Facilitating, that's the first time we see the word, and we're going to see it's very important. After the Sustainable Development Agenda, there was the migration crisis of 2015 in the Mediterranean for Europe, the Rohingya in Asia, as well as the Central Americans arriving at the American border. So in three continents, there was a migration crisis, and the UN called, and Barack Obama called the 2016 New York conference, which adopted a declaration and announced two covenants on two compacts, on refugees and on migrants. And we're going to see the second one, the Global Compact for Safe, Orderly, and Regular Migration. This Global Compact is not the wet dream of a law professor or a philosopher. It was negotiated by states, and it was approved in a resolution of the United Nations General Assembly by 153 states. So you see, it's much more universal than the 1990 convention. It's not a document of hard law, it's a document of soft law, it's a resolution, just like the Universal Declaration of Human Rights of 1948, but it was negotiated not by politicians, and that was the key. It was negotiated by civil servants, diplomats, experts, international organizations, civil society organizations, academics. It was discussed, and negotiated at a lower level, not in the political arena. And the politicians only reacted very late. The text was finalized in July 2018, and politicians reacted in November 2018. And at that time, a few countries voted against it, 12 abstained, but 153 voted in favor. And that's an important landmark. It only creates a conceptual framework, a sort of critical path for the coming decades. And unfortunately, it says things which go directly against what states are doing in the current era. So states will have to change their practices relating to immigration and mobility. But hopefully we can think about this Global Compact as having long-term influence. Like the Universal Declaration. It was adopted in 1948, and we are still 70 years later developing this human rights doctrine that it created. And the thrust of the Global Compact is in the word to facilitate or facilitation. That's the central recommendation. In the English version, which was the negotiated version, it is used 62 times. I counted them. So the idea is for states to make mobility easier, which is not exactly what most of our countries are doing currently. Most states insist on repression, and 3 of the objectives of the Global Compact show that states will need repression. And this, we will need repression for smuggling, trafficking, managing borders. I see that I'm getting behind here. But many objectives go towards better protecting the rights of migrants. For example, Objective 5, we commit to adopt options and pathways for regular migration in a manner that facilitates labor mobility and decent work. And they add a right to family life, which actually does not really exist in international human rights law, but is developing as the human rights doctrine is developing. This means that if you have a right to family life, it means that as a migrant, you would have the right to bring your family with you. Now, the vast majority of temporary migrant workers do not have that right at present. But states have said, 153 states have said, this is the way of the future. Family reunification, right to family life, best interest of the child. Again, insisting on this right to family life and the importance of family unity. And you see, it's written, facilitate access to procedures for family reunification for migrants at all skills levels. That includes the vast majority of temporary migrant workers. Fair and ethical recruitment, guarantee of decent work. I mean, all is required from states in this objective is to apply their own labor law. Because in the vast majority of states, the labor code is good. It protects everyone. So apply your own labor law, which seems to be very simple, but actually doesn't happen much. Facilitate change of employers and facilitate the modification of the condition or length of their stay. At present, in many countries, either you have to go back home and come back, or it'll take months before these change can happen. And in the meantime, you are in a very insecure administrative situation. Facilitate transitions from one status to another. Reduce precariousness of status without fear of arbitrary expulsion. That's what migrants fear most. This is an interesting one. In fact, it's regularization of undocumented migrants. The word regularization has disappeared in the English negotiated version, but it has reappeared in the French translation. So the word régularisation is there in French, but not in English. But that's what it says. Facilitate access for migrants in an irregular status to an individual assessment that may lead to regular status. This is regularization. So the paragraph is there, even though politicians didn't want to see it, to see the word regularization. Crisis preparedness, emergency response, post-crisis action. This is key. This is essential for refugees. What is said here is that states should prepare for migration crises, just like they prepare to protect the victims of forest fires or earthquake or floods. We prepare for these civil emergencies. Well, we should prepare for migration crises as well. And if we do, they won't be a catastrophe. They will be governed, organized, and we will have prepared for that so that they don't become the kind of catastrophe that we've seen in the Arizona desert or on the beaches of Greece or in Asia for the Rohingyas. Provide access to basic services for all migrants regardless of their migration status. Quite extraordinary. All migrants, regardless of their migration status, should have access to basic services. That's, social security and health care and education. That's an interesting element. They provide for firewalls. The word firewalls was there in the draft, but disappeared because the politicians didn't, it was a sensitive word, but the paragraph stayed. Prevent cooperation between service providers and immigration authorities that could hinder migrants in accessing their basic services. So firewalls between, for example, hospital files and immigration files. Here, something that I find very interesting. Foster inclusive and cohesive societies by empowering migrants. The word empower is extremely strong. It is the contrary of what's happening. The whole precarization of migrants is based on the idea that we need to disempower them so that they will accept the working conditions that reduce labor costs. And here, the states have said we should empower migrants to become active members of society, which probably includes allowing them to unionize and to defend their rights and to negotiate their working conditions. It's here, accepted by 153 states around the planet, north and south. Eliminate forms of discrimination. Promote an open and evidence-based public discourse. Generate more realistic, human, and constructive perceptions of migrants. Yes, we need to change perceptions, absolutely. And maybe the pandemic has helped. We have seen in many countries migrant workers be deemed essential to the economy. For example, in my country, healthcare workers and agricultural workers were deemed essential. It hasn't led to bettering their working conditions, but at least there was a recognition that they were part of our society and we needed them. Invest in skills development. We've been talking about that for years and it's not happening. There are blind spots in the Global Compact. I'll leave you with that. And there's a way forward. We cannot implement the Global Compact overnight. We need to facilitate mobility, but we cannot do this in a day or in a week or in a month or in a year, because whole sectors of the economy would go belly up. Farms would not be able to bear the cost of labor if tomorrow we ask them to pay what a normally regulated labor market would request, i.e. citizens, for example, would request to come and work as agricultural workers. This is not happening. So we need long-term strategic planning of mobility in order to prepare those industries to bear the labor costs and prepare the population to bear the labor costs. And this is what we do for all sectors of governance, for energy, for infrastructure, for transport. Governments are doing long-term strategic planning, 20 years, 50 years. We know that the highways that are built today were often planned 20 or 30 years ago. And that's the only way to make development sustainable, is that you have a plan. And you need to have everyone discussing, not simply the Minister of Immigration or Home Affairs. You need to have all the stakeholders, including the unions and the migrant associations. And you need to have the voice of the migrant themselves. And that voice is systematically absent from the creation and implementation of migration policies. We need fluid border crossings where migrants are allowed to come and go and look for work according to their own priorities. We need to make mobility easier, safer, cheaper, and faster. And this is what free movement zones have done. The EU, the projects with ECOWAS and SADC and at the African Union level, but also the Southern Cone in Latin America, allowing people to go through borders. Easier, safer, cheaper, faster. You know, the idea is that governing migration is about legalizing, regulating, and taxing mobility, not prohibiting mobility in order to reduce labor costs. Sorry, I need to do that. Yeah. We have to reduce migrant precarity. They won't speak up unless the precarity in which they live and the risk of being returned home empty-handed is there. We need to develop international mobility cooperation. No state can go it alone in that. So we need, indeed, probably regional approaches like free movement zones, on skills recognition, on crisis response, on etc. We need that. We need a collective response. Local governments will have a big role in the integration of those migrants. Cities are already integrating the vast majority of migrants around the world, and they need support. And you see there are plenty of initiatives to help mayors be leaders in migrants integration. We need a harm reduction philosophy instead of a zero tolerance policy. The fact that a migrant is undocumented, has entered undocumented, or has left has, has a visa that has expired is not a huge issue. It's like driving without your driving license on you. You're going to have a stiff fine if you're asked for your driving license and you don't have it, but it doesn't make you a dangerous driver. It just makes you a forgetful driver. And you are going to have a fine, but it's not a problem. So instead of, for example, sending back undocumented migrants, what if we regularize them and ask them to pay a fine? $500, $1,000, whatever. They will often be able to find money from family, from loan sharks, etc., to pay for smugglers and other facilitators. They would be able, if we provided papers, they would be able to pay a small fine, and that would reduce the problem for the host country and make them able to negotiate their working conditions. And so empowering migrants has considerable advantages. It reduces the pressure on refugee determination systems. Most refugees would ask for a work permit instead of refugee status. It's much simpler. It reduces the power of criminal networks because we're not subsidizing criminal networks. It enhances the capacity of border control because people will go to the border guard with their papers instead of paying smugglers. And this was the case of the 50s, 60s, and 70s. People could move easily across borders at that time. Migration was not seen as a security issue. It was essentially a manpower, an employment issue, a social issue. And so the Global Compact has triggered conversations. And I think this is going to take time. And I fear that we need a generational change where, and we see silver linings today already with artists talking about migration, and the media is much better educated very often. The youth, the urban youth, doesn't fear migration. They live in schools where there is diversity and very often. And the migrants themselves have been and continue to be heroes for their community, for their families. And these are narratives that we need to include in our collective narratives. Their agency, their resilience, their courage, their imagination will inspire everyone to do much better. Oops, sorry, here. And so, in conclusion, I hope the Global Compact will create a culture of human security for migrants in the same way like the Universal Declaration, as the Universal Declaration created a culture of human rights. And we are still developing that culture of human rights. I hope it will come earlier rather than later. But one thing is for sure is that what the Global Compact announces is not what states are doing now. Most states are doing now. But with the follow-up, with good practices, lessons learned from around the world, and especially with another generation that doesn't fear migration like my generation, which is in power at the moment, we might get somewhere where migrants are not systematically exploited. Thank you very much.